Good afternoon, ladies and gentlemen. It's Tuesday, March the 19th, 2024. Welcome to the Civil Justice Subcommittee. Madam Clerk, please call the roll.
Good afternoon. Representatives Bolso, Capley, Eldridge, Farmer, Grills, Lamberth, Parkinson, Todd, Chairman Russell. Chairman, you have a quorum.
Thank you, Madam Clerk. Members, do we have any personal orders this afternoon? Personal orders. Seeing none, just as a reminder to all members, if you vote in opposition and wish to have your vote recorded as such, please check in with TJ after the vote. And we got a few housekeeping items. First is item number 3, House Bill 2282. Without objection, taken off notice. Next will be item number 9, House Bill 2919. Without objection, taken off notice. Next will be item number 10, House Bill 2926. Without objection, rolled 2 weeks to April 2nd. That brings us to item number 1, House Bill 2449 by Representative Miller. Is Representative Miller here? Without objection, we'll roll item number 1, House Bill 2449 to the Hill. Brings us to item number 2, House Bill 2839 by Representative Towns. We have a motion and a second, and we'll roll item number 2, House Bill 2839 to the Hill without objection. Brings us to item number 4, House Bill 2117, and Representative Powers is not here, so we'll, without objection, roll him to the Hill. Item number 5, House Bill 2384 by Chairman Howe. We had a motion and we got a second. Chairman Howe, you are recognized, and I show an amendment. Actually, I show 2.
Thank you, Mr. Chairman, and I'm glad to say that I was here on time.
You were bright and early. What amendment code do you have?
The one I have is 15571.
That's what I got. We got a motion and a second. Does it rewrite the bill?
Yes, it does.
All right. Without objection, we'll be voting on House Bill 1557. I'm sorry, on the amendment. Amendment number 15571 to add to House Bill 2384. All those in favor signify by saying aye. Opposed, no. The ayes have it. All right, Chairman Howe, you're recognized on House Bill 2384 as amended.
Thank you, Mr. Chairman. And members, there are several school boards in the state of Tennessee who enter into contracts with independent school bus drivers to transport students to and from school. Through the years, there have been some conflict and misunderstandings over the liability insurance coverage for these bus contractors. There have been cases actually following an accident where the bus contractor thought that they were covered for liability tort insurance through the LEA's insurance, and that was not the case. So House Bill 2384 seeks to clarify what additional insurance an independent bus contractor needs to have. And there is, by the way, an AG opinion that says independent bus contractors cannot be covered under government tort liability. So therefore, this bill just clarifies that an LEA, when entering into a transportation contract, will assist the bus contractor to make sure they have the proper liability insurance coverage in case of an accident. But it clarifies that the LEA cannot be the secondary insurance for the contractor. So it's a clarifying bill. With that, I ask for passage.
Very good explanation. Members, we got any questions for Chairman Howe? Seeing we got a question on the bill, we're voting to send House Bill 2384 to Civil Full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Congratulations, Civil Full.
Thank you, Mr. Chairman and Committee.
Thank you. Brings us to item number 6, House Bill 1349 by Chairman Farmer. We got a motion and we got a second. Chairman Farmer, you are recognized. I show 2 amendments.
Yeah. Thank you, members. I do have 2 amendments, and if we could Mr. Chair, move with Amendment 15576.
We got the motion and we got a second on Amendment 15576. We're voting to add Amendment 15576 to House Bill 1349. All those in favor signify by saying aye. Aye. Opposed, no. The ayes prevail. Chairman Farmer, you're recognized on House Bill 1349 as amended.
Yeah, thank you, Mr. Chair and committee members. This is something I've been interested in for a few years. And what this does, this would raise the presumptive medical bills that could be brought in front of a general sessions court. So say if you're hurt and it's under $25,000. So right now, general sessions court has the jurisdiction to handle cases $25,000 or under, except for some detainer stuff. But we're talking, say you're hurt in a car accident, and you have right now, if you have $4,000 worth of medical bills, you can file that along with your complaint, and the court would then presume that $4,000 of those bills were reasonable and necessary, without you really having to bring in any other proof whatsoever. Of course, that could be rebutted probably by the defendant, but on any account, typically that's where it's at. I had intended to bring it and raise it to $15,000 across the board, but that seemed to be something that may be somewhat unattainable. So I ended up, by agreement, raising that amount to $8,000, but that would only include the presumptive medical bills. There would only include medical, hospital, doctor bills, hospital emergency care, surgical procedures, or inpatient hospital admissions. So it does reduce the scope of those presumptive medical bills, which, for example, would not include chiropractor bills and things of that nature. So that's what I brought to the committee. I'm at the will of the committee. However, the committee would like to move forward, but that's what I'm proposing we adopt and work on.
Thank you, Chairman Farmer. And without objection, we'll go out of session. We got two people here to testify. And if Ben Sanders and Scott White will come forward. And if y'all will just identify yourself, you have 3 minutes apiece, and whoever wants to start first is welcome to. Just make sure that red light is on. Identify yourself, and we'll start timing just as quick as you start talking.
Okay. I'm Scott White. I represent State Farm. Thank you, Chairman and committee members, for giving us the opportunity to speak today. I think the sponsor has cured any problems that State Farm may have with the bill with his amendment. Our really only concern was with the amount of increase for the presumption. $25,000 we thought was much too high, and was actually a 525% increase over the existing statute amount. And 15,000 was 275% over the existing statute amount. 8,000 is 100% increase to what is currently in the statute, and that jives fairly well with inflation over the past 20 years for medical services. So we're certainly appreciative of the sponsor's efforts in this regard.
Thank you, Mr. White. Mr. Sanders, if you'll just identify yourself, and as soon as you start talking, we'll start timing, then we'll take questions.
Thank you, Mr. Chairman. I'm Benjamin Sanders with Farm Bureau Insurance. The first thing I would like to say is we deeply appreciate the sponsor and his willingness to hear many sides of this issue and to engage in a lot of discussions. That's noted and deeply appreciated. I'd also like to say thanks to the Tennessee Trial Lawyers Association. As you all can imagine, insurance companies and attorneys don't always get along, but we have a really good working relationship in Tennessee. That doesn't happen by accident, and so we appreciate the relationship we have with them. I'll echo Mr. White. The amendment proposed by Chairman Farmer is very acceptable to us. We had significant concerns with the bill as filed. To put it in perspective, and due to time constraints, Mr. Chairman, I won't go through the calculations, but to put it in perspective, we analyzed the bill as filed and estimated that it would cost us an additional $46.2 million a year. Now, 2 points I'd like to make on that. Actually, I'll just make 1 point. In these cases, the insurance company doesn't get sued. It's our member that gets sued. It's the individual that gets sued. Because of liability coverage, we handle that and that defense for them. but it's the individual that gets sued. So when we talk about saving money, it's not money that comes from us, it's money that comes from our policyholders. I think that's an important note to make. We, again, appreciate the sponsor. This amendment alleviates our concerns to the best of our knowledge. This limitation, this amount, even increasing it with the limitations, we feel like would add a negligible cost to our members, while also increasing, as Scott said, with medical inflation and keeping up with that. And with that, Mr. Chairman, I'm happy to answer any questions.
Thank you. And members, we got any questions for the witnesses? All right, seeing none, we appreciate both of you being here and appreciate you coming to my office and talking to me about the bill. Thank you. Without objection, we'll go back in session. Any questions for the sponsor? The question's been called. We're voting to send House Bill 1349 to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full. Members, without objection, we're going to take item number 4 out of order by Chairman Powers. Item number 4, House Bill 2117. We got a motion and a second. Chairman Powers, you're recognized.
Thank you, Mr. Chairman and committee. House Bill 2117, last year we passed a bill which became Public Chapter 479, which prohibits the state or any local government entity from adopting or implementing policy recommendations that deliberately or inadvertently infringe or restrict private property rights without due process, and may be requiring the policy recommendations originating in or traceable to anything the United Nations or a subsidiary entity of the United Nations. It was a good law, but it had no teeth in it. House Bill 2117 requires, as part of a local government's annual audit, the executive of the local government entity to present a written confirmation to the comptroller of the Treasury certifying that the local government entity has not sought or received a grant in intentional pursuit of a policy relative to Agenda 21, the 2030 Agenda for Sustainable Development, excuse me, net zero goals, had a little allergy problem, or 2050, or another international law or additional plan of action that violates the U.S. Constitution or the state constitution. House Bill 2117 authorizes an individual who believes that a political subdivision has violated present law to bring a private right of action in a court of competent jurisdiction. And with that, Mr. Chairman, I renew my motion.
Very good explanation. Members, we got any questions for the sponsor? The question's been called. We're voting to send House Bill 2117 to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full. Congratulations.
Thank you, Mr. Chairman. Thank you.
Thank you. Next up is item number 7, House Bill 2001 by Chairman Farmer. We got a motion. We got a second? We got a second. Chairman Farmer, you're recognized on House Bill 2001, and I'm showing an amendment.
Yeah, and thank you, Mr. Chair. If we could adopt House Amendment, 15105?
That's what I've got. We got a motion and a second on Amendment 15105. All those in favor for adding it to 2001, say aye. Opposed, no. The ayes prevail. Chairman Farmer, you're recognized on the bill as amended.
And thank you, members. And this piece of legislation is somewhat complex, and I do have some folks here to testify, so I don't muddy the waters too much for the members. But just to hit big picture on this, our Supreme Court came down just, I believe, back in September and made some adjustments and some interpretations of a law that had been in place since 1975. And what that law had to do with was health care liability actions. So we're not talking about car accidents or anything like that. We're talking about medical malpractice suits. So with that short explanation, Mr. Chair, if we could we go out of session and hear from our experts on this?
Absolutely. Members with objection will go out of session. And if Allison Lynch and Craig Sanders would come up. And y'all will have 3 minutes. And if you'll just identify yourselves, make sure your red light's on. And as soon as you start talking, we will start timing. And whoever wants to start first is fine.
Good afternoon. Good afternoon. Sorry. My name is Craig Sanders. I'm an attorney with the law firm of Rainey Kaiser, Revere and Bell in Jackson, Tennessee. For the past 22 years, I have spent the bulk of my career defending medical malpractice, or what we now call healthcare liability cases. In 1975, the General Assembly passed the Medical Malpractice Act, or what we now call the Healthcare Liability Act. One of the primary purposes of that act was to retain and attract doctors in Tennessee and healthcare providers so that we could provide excellent health care to all Tennesseans. One statute in that act was 2926-119. That statute in particular addressed the damages that you could obtain in Tennessee in medical malpractice cases. In essence, it said in regards to medical expenses that you could recover actual economic losses. That statute was interpreted for many years by trial courts, both state and federal, in different parts of the state as to meaning that a plaintiff in a medical malpractice case could recover any amount of medical expenses that's actually paid or owed or payable. But you could not recover those that are discounted or written off. In September of last year, the Tennessee Supreme Court, in a decision that was not unanimous, interpreted that statute differently than those trial courts had for many years. The Supreme Court said that you could, in a malpractice case, can now obtain the discounted amounts. So if you have a service that's $100,000 and the discount, the health insurance company pays $60,000, the other $40,000 is written off, you now can recover that in a malpractice case. This bill aims to put the law back the way it was prior to September. And it's important because of the amount of expenses that are involved. I had a case just last year where the difference was nearly $1 million in billed versus what was actually paid and written off. And you can imagine that case times another case where we're looking at millions, then getting to 10 millions of dollars over time. So I appreciate the opportunity to be here, and I'm happy to answer any questions, Mr. Chairman.
We appreciate you. And Ms. Lynch, would you like to comment?
Hi, Chairman and Committee, Allison Lynch, lobbyist for Baptist Memorial Healthcare. Mr. Sanders, quite frankly, explained, I think, the current state of affairs very well, and I am happy to help answer any questions that the committee has.
Thank you. Members, do we have any questions? Seeing none, Chairman Farmer, you recognize.
Yeah, just real quick, and thank you. And I appreciate you all being here. I just wanted, if either one of you could take this, just to help to explain to members the differences in that, or to make this clear that this only applies to healthcare liability actions and not general actions in tort, and how and why we know that this doesn't cross over that threshold.
That's correct. So what this bill would do, when the Supreme Court decided the case I was referring to in September, the Crotty versus Dr. Flora case, the Supreme Court said that the statute as written was not clear, that it was not the model of clarity, was their words. So what this statute does is rewrites it to be clear, but it's only in medical malpractice or what we call healthcare liability cases, and it's part of that Healthcare Liability Act. It would have no application outside of a healthcare liability context.
Thank you. Thank you, Mr. Chair.
Thank you. Representative Bolzo, you recognize.
Thank you, Mr. Chairman, and thank you for being here. Let me, if I could, just get into the Crotty decision with you. Is it accurate to say that typically in a personal injury case, a plaintiff is entitled to recover the reasonable and necessary medical expenses incurred that were caused by the defendant's wrongful conduct?
Yes, I think that's accurate.
And that amount may be higher or lower than what a injured party actually paid. Would you agree?
I'm not sure I can agree to that part of it, Representative Bolso. If the hospital or medical clinic or doctor, whoever is accepting per some agreement a lower amount, I would think that would be reasonable as well. So I think you could have a scenario where multiple numbers are reasonable cost.
Let me ask it this way. If this bill were to pass in its current form, what would be the effect of the collateral source rule on the recovery of medical expenses in a healthcare liability action?
In regards to the healthcare liability action, the collateral source rule was abrogated initially by 2926-119 in 1975. And actually, the Supreme Court had recognized that in the Dedman versus Steelman decision just a few years ago. But this statute would uphold that abrogation of the collateral source rule, at least partial abrogation, in medical malpractice or healthcare liability cases only.
Would you agree that the way that the tort system is currently structured, that if everything works perfectly, an injured party is typically undercompensated by about 40%, meaning that the injured party will ordinarily pay 1/3 of a recovery in attorney's fees plus expenses.
No, I don't think I have data that I could agree with that. I will say that this statute, or this bill rather, has no implication on any other area of damages that a plaintiff can recover in a medical malpractice case. They could still recover whatever amount they otherwise could for emotional distress, for pain and suffering. This bill only regards medical expenses.
So in a healthcare liability action, if a plaintiff put on evidence that the reasonable and necessary medical expenses totaled $100,000, but the plaintiff had only paid $75,000, as I understand this bill, if it passes, the plaintiff could only recover $75,000. Is that correct?
I think, let me make sure I understand. Pursuant to this bill, the plaintiff would only be able to put on proof of what was actually paid or is owed and payable. They would not be allowed to put on proof of any discounted or written off amount. So you're correct in the sense that they'd only be able to recover the paid amount, and that's the only amount that would be able to be put on proof at the trial.
Great, thank you.
Thank you. Any other questions for witnesses? And seeing none, we appreciate both of y'all being here. Hope you have a good rest of the day. Thank you. Without objection, we'll go back in session. We got any questions for the sponsor and Representative Bolzo?
Thank you, Mr. Chairman. And sponsor, I certainly appreciate the intent behind the bill, but it concerns me because it does, abrogate the collateral source rule in healthcare liability actions. And the collateral source rule has historically been both a rule of evidence and a rule of damages. I mean, the collateral source rule would not exclude from evidence any other sources that were used to pay any damages that a plaintiff suffered in a case. And typically, in a personal injury case, and specifically in a healthcare liability case, the amount that a plaintiff pays may equal, it may exceed, it may be less than the reasonable and necessary medical costs. And in most personal injury cases, in fact, perhaps all other than healthcare liability actions, a plaintiff is entitled to put on evidence of reasonable and necessary medical expenses and to recover those expenses as part of a damage award. And in my view, that system of recovery is superior to what is in the bill, because the bill will reduce to an amount paid the medical expenses that a plaintiff can even prove in a healthcare liability action, even if the amount paid is less than the reasonable and necessary cost of medical expenses. So given all of that, I mean, do you have any concern that this particular bill may favor a defendant in a healthcare liability action more than a plaintiff?
Chairman Foreman, you're recognized.
And I appreciate those comments, Representative Bolso. And here's the way I look at it. This statute was enacted, I believe, 29/26/119 in 1975. So from 1975 up until just September of 2023, this General Assembly felt that it was appropriate. Up until our state Supreme Court said, hey, they took a look at this law, and I don't believe that the opinion was directly related, or the ask to the Supreme Court wasn't a direct ask to evaluate the way medical healthcare liability actions were litigated with regards to the collateral source, as we were talking about. So from 1975 up until September of 2023, this General Assembly didn't feel the urge to change anything. Our Supreme Court did. So when this bill was brought to me, the ask was, hey, this has worked well for so long. Our Supreme Court has came in and made a couple of interpretations. I know you've read the opinion probably more than once, and made this recommendation, and also say that the statute wasn't clear. So what this would do, this would just bring this portion of the law back to the way it operated. And look, I'm at the will of this committee. I mean, we're all policymakers up here. I've not twisted anybody's arm one way or another to do anything. And I just ask that you all just take into consideration what's been, we've had some great folks down here to testify today, did a great job explaining what was going on. And your comments are well warranted, sir, I will say, and I appreciate your opinion, I do. But I just ask that if you don't have any more questions, I just move for passage.
Chairman Bozo, you're recognized.
Thank you, Mr. Chairman, and thank you, sponsor. My only comment will be that I'm going to have to vote no on this particular legislation because I do believe that it is somewhat anti-plaintiff in that it does not allow a plaintiff in a healthcare liability action to prove and recover the same type of damages that plaintiffs in non-healthcare liability actions can recover. In all but these healthcare liability actions, a plaintiff is able to prove and recover reasonable and necessary medical expenses. And then through subrogation principles and other principles of law, sometimes those amounts are shifted to other parties who are not a party to the case who bore the expense. But in my view, we'd have a better tort system if we had a rule that was across the board in all personal injury cases that plaintiffs are entitled to prove reasonable and necessary medical expenses and recover those. And for that reason, with the utmost respect, I'll be voting no on this.
Thank you. And Chairman Farmer, any follow-up?
Yeah, and I will say this, members and Representative Bolso, I think there is a clear difference in a medical-related healthcare liability case and a car accident. You know, the medical field professionals, and we've got certain guardrails even on those claims when they're brought forward. So I think that it would be hard to have just a blanket rule that would cross over from a truck driver, an accident regarding a truck driver, or just a regular Class A licensed driver and a medical doctor who's practiced medicine. That's all I've done for 20 years. So I think that may be a difference, or one reason I could rationalize it being treated a little bit differently, just because of the professionalism involved, just as we were maybe treated a little bit different as lawyers in our malpractice lawsuits there too. You know, there's a higher standard there and different standards than just your average car accident case. So that's all I have to say.
Representative Bozo, you got anything else, sir?
Nothing further, Mr. Chairman. Thank you.
Thank you. We don't have anybody on our list, so we'll be voting on House Bill 2001 to send to civil full. All those in favor signify by saying aye.
Aye.
Opposed, no. The ayes prevail. Civil full. Congratulations. Next up is item number 8, House Bill 2002 by Chairman Farmer. We got a motion and a second. I do show 2 amendments.
Mr. Chair, if I could move with House Amendment 16538.
All right, we got a motion and a second on Amendment 16538. We're voting to put 16538 onto House Bill 2002. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Chairman Farmer, you're on House Bill 2002 as amended.
Yeah, and thank you, Mr. Chair. And members, what this does is there's been a lot of talk ever since when I first got here in 2012, I guess it was fiscal year 2013. And I remember Lieutenant Governor Ron Ramsey was real interested in a thing called judicial redistricting. And what that meant was he had a plan, or there was a plan out there that made it all the way to the House floor. And there was some very spirited and heated debate about what we were going to do with these judicial districts, and whether or not judges were going to lose their seats and district attorneys. And we had a long discussion about it. And then it ended up ultimately failing on the House floor. I remember Representative Sanderson gave one of the best speeches I was ever heard that day as a new member. But members, what this does just a little bit of that. But what this don't do, this doesn't take anyone's job away. What this amendment proposes to do is to relocate what will be 2 vacant judge positions in West Tennessee and reallocate those positions in Middle and East Tennessee and judicial districts out there. And what the basis of this is, this is just not something I just thought of and thought would be a good idea. And I'm not picking on one side of the state or another. We've had several weighted caseload studies that shows that this area of the state has been overjudged by right at 2 judges for a period of time. And the AOC has made recommendations earlier in this year that there were 4 judicial districts that needed judges. And one of them, and this would satisfy 2 of those needs. I believe the governor had put in his budget a 3rd district there, but we still have a district that is underjudged that I hope we'll be able to satisfy that too. So once again, the most important part of this, we're not taking anyone's job here. These will be vacant seats that will be reallocated and relocated to portions of the state that need them the most. So with that said, I'll renew my motion.
Thank you, Mr. Chairman. Very well explained. Do we have any questions? And Representative Parkinson, you're up first.
Thank you, Mr. Chairman, and to the bill sponsor. I've received more calls about this legislation over the last few days than probably any legislation, honestly, that this year. And a lot of calls from our judges, and information from our clerks. I understand that these 2 positions are vacant, but for us, these positions need to be filled and kept in Shelby County. And I think it's important to, and I told you this before, so it's not an ambush or anything, but I think it's important to note that today the Tennessee trial judges voted to support that no judge seats will be eliminated at this time, and that they're asking the legislature to delay any action until they can get accurate information for the legislature and the comptroller to rely on, since the last weighted caseload study and the onset of COVID, the information is not as accurate as it could be. Also, they said they support the governor, including in his budget funds to approve 2 new positions for the 4th and 19th judicial district. And so, we're asking that you don't run this bill as amended, so that we lose those 2 seats in Shelby County. And I do understand that those seats right now are not filled because our Supreme Court Justice Wagner being appointed and the loss of a judge, due to other challenges. But we need those seats in Shelby County in order to get the trials and the hearings that the people in Shelby County need, especially given that it is our most populated city, in our state. And so I ask that you give that some consideration, Mr. Sponsor.
And Chairman Farmer, you're recognized.
And just a couple things in response, and we have talked just briefly beforehand today, and I appreciate our conversations, although brief. I've heard different regards from the Trial Judges Association, but hopefully next week, if this bill were to pass committee, we will have the opportunity to bring folks in and testify in front of Civil Justice Full Committee, and we can ask questions to those folks with regards to that. And Representative Parkinson, I'd be happy to support any sort of weighted caseload study that we may do in the future. And if it shows that, in fact, Shelby County at that point in time is down 2 judges or 3, I'll be happy to support putting those judges where they need to be. But from my information, as I understand it now, this is the fair and proper move to make. We're not taking, this is an opportunity to reallocate these positions to parts of the state that needs it without taking anyone's job. We're not cutting anyone's term short or anything like that. So I think this is the most appropriate time to make this move. And I do appreciate your position, and I do appreciate you advocating for your constituents in your community.
Representative Parkinson, any follow-up? All right, we don't have anybody else, so we're voting on House Bill 2002 to send to Civil Full. All those in favor signify by saying aye. Aye. Opposed, no. The ayes prevail. Civil Full, congratulations. Next up is item number 11, House Bill 2859 by Chairman Reagan. We got a motion and a second, and Chairman, I'm showing an amendment.
Yes, sir. Thank
We
you.
got a motion and a second on the amendment, so
The amendment is 15820.
that's what I got. Does it rewrite it or?
Yes, sir, it does.
All right, we're voting to add 15820 to House Bill 2859. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Chairman Reagan, you're recognized on House Bill 2859 as amended.
Thank you, Mr. Chair. Members of the committee, this is a very simple bill. In fact, the 3 paragraphs of the bill are the best talking points I could give you. It says the owner of land who's entering into a cooperative agreement with public land owned by the federal government. And I will tell you, this comes from my district. One of the philanthropists in my district is building a park adjacent to some TVA land and has put considerable funds into it, only to discover after that happened that the liability that he would be accepting by allowing the public to use those lands is not the same as if it was a public park. All this bill does essentially is say that the liability is going to be the same. It does not, however, excuse any liability from gross negligence or willful or wanton misconduct. With that said, this is a boon to my district. I encourage you to consider the good that would be done, and please vote for it. I stand ready for questions.
Thank you. Do we have any questions? Seeing none, we're voting to send House Bill 2859 to full civil. All those in favor signify by saying aye. Opposed, no. The ayes prevail.
Thank you,
Full
Mr. Chair
civil.
and committee.
Congratulations. That brings us back to the first of our calendar, item number 1. Without objection, we'll roll that to the Hill. Brings us to item number 2, House Bill 2839 by Representative Towns. We got a motion. We got a motion and a second. And Representative Towns, you're recognized on House Bill 2839, and I do not show an amendment.
You are correct. There are no amendments, and I apologize. I was running bills in another committee over there, so I couldn't get here. Thank you for rolling me to the Hill. And if you don't mind, Mr. Chairman, I have 2 people that would like to testify. They've already testified in the Senate, so I'd love to go out of session and have Ms. Hill and Ms. Tucker to come up.
That
And,
would be
talk
great.
to the
Members
bill.
without objection, we'll go out of session.
Thank you.
And Ms. Tamara Hill and Darlene Tucker, if y'all would come up and please have a seat. You'll have 3 minutes apiece, and just make sure your red light's on. And if you'll just identify yourself, who you're with, and as soon as y'all start talking, we'll start timing.
Mr. Chairman, committee members.
Make sure your little red light's on there. There you go.
Thank you. There's 2 red lights. I only had
We'll
one.
get this show on the road.
Yes. Mr. Chairman, committee members, good afternoon. Thank you so very much for your time. My name is Darlene Tucker. I am a certified financial planning professional and a longtime Tennessee resident. In my practice, I am bound by a fiduciary standard, which basically just means that recommendations I make are required to be in the best interest of the client. While I do not give legal advice, it is my responsibility to understand how my recommendations are impacted by various laws. It's worth noting that the type of accounts that are subject of this bill are accumulated over a very long period of time, often through payroll deductions. This includes state pension benefits, IRAs, 403Bs, health savings accounts, and a few others. Direct IRA payments are capped at $7,000 for the current year. The accounts that this bill seeks to protect, by the very nature of their funding, cannot readily be used to shield large sums of money that might result from illegal activity. Without the clarification that this bill provides, no one in the financial services industry should recommend IRAs or 403Bs to Tennessee residents. And the 403Bs are the IRA equivalents for educators and government employees. This should not be recommended without disclosing the risk that these funds may be lost to a judgment resulting from unforeseen circumstances. Tennessee has benefited economically from the influx of retirees as well as major corporations. This clarification, that these folks moving in help our small businesses and our communities thrive. Clarifying this vital protection, combined with the fact that we do not have a state income tax, keeps our doors open. Failure to decide to do this clarification could become a deciding factor when people are comparing Tennessee to other states. Why would retirees with sizable IRAs or company executives risk their financial security in retirement by moving to Tennessee? This bill does not add or change current protections for these accounts. It simply clarifies the stated intent of this legislative body and adds no cost to the state. I believe it is extremely important to ensure that Tennessee remains attractive to employers and retirees while also protecting retirement security for our longtime residents. Mr. Chairman, I thank you again for your time, and I'm happy to address any questions that you may have.
Thank you. And Ms. Hill, would you like to go with your testimony for 3 minutes?
Yes, thank you, Mr. Chairman. Members of the committee, I appreciate the time to be able to speak with you today. This happened from something in our district in West Tennessee. We had a law firm decide that they would try to get an IRA. Now, we've traditionally believed that IRAs were exempt from creditors, and in fact, we have a statute, 262105, that says exactly that, that IRAs and certain other qualified plans are exempt from creditors' claims, except for the state of Tennessee or a quadro, which involves child support, divorce, stuff like that. This law firm decided to take 262111, which is another part of the bill, another part of the statute in that series, and use it. It is for non-qualified plans. And they decided to try to use that statute to add additional exceptions to the exemptions found in 262105, where they are actually spelled out. I like to say it like this. 262105 covers apples. 262111 covers oranges. The court made fruit salad and tried to apply the law governing oranges to the apples. Now, our Court of Appeals has overturned that decision by the trial court, and our Supreme Court has denied review. So the person's IRA that started this whole mess is protected, but it opens the door for other people to misconstrue those statutes and go after other people's state retirement, IRAs, other plans that would normally be considered qualified plans and exempt from the claims of creditors. As Ms. Tucker said, the amendment to the statute does not change anything. It just clarifies that 262111 was not meant to abrogate 262105. And again, I'm open for questions as well.
Thank you, Ms. Hill. Any questions for Ms. Hill or Ms. Tucker? And Representative Bolzo, you recognize? And you are welcome to go back and forth too.
Thank you.
Thank you, Ms. Hill. Obviously, I missed part of your testimony because I was in hearing room 2 presenting a bill.
Sure.
But let me just back up if I could. Does this bill, if enacted, reduce a judgment creditor's ability to satisfy a judgment from the judgment debtor's assets?
No, because Tennessee 262105 already exempts IRAs from the claims of creditors, except for those of the state and of a quadro. So we've had that enacted, and I think I brought around maybe last week to you all a handout, and I think I emailed it as well with the links to the legislative history. Tennessee 262105 has gone through different numbers, but it's been the same bill, and it's been in place since the 70s. And so if you go back and you listen to those recordings of legislative history, you will find that the important things were to encourage people to save for retirement and to make sure that they're not on welfare. What we don't want to happen is for someone to play by the rules, save for their retirement year after year, and then something happens. Maybe they're in a wreck. Maybe someone sues them. Maybe they have astronomical medical bills. So they've always played by the rules, but then we're going to let a creditor take away all that. That disincentivizes any saving for retirement if it can be taken away from you. And in the underlying case that brought this to my attention and why I'm bringing it to you, the argument was, well, 262105 protects the IRA until you can get the money at 59 and a half. Well, that's absurd. What's the point of a statute that protects money until you can, and as long as you can't get it, but doesn't protect it once you can? It would, and like I said, our Court of Appeals has already said this trial judge was wrong, and the Supreme Court has already said, we're not going to look at it. We're not going to grant the appeal, permission to appeal. Back in the legislative history, the Attorney General actually also did an opinion on this. And again, it was that the purpose was to save for retirement and to keep people off of welfare. And so that's been the purpose for 50 years. And what we're asking in this bill to amend 26-2111 is merely to say, this applies to the oranges. We weren't doing anything to the apples when we put it in. 26-2111 was a reaction to the federal bankruptcy law changes. And that's when our legislature went through that and added these additional exemptions for things like deferred compensation plans, Social Security, VA benefits, even benefits that are awarded because of a crime victim benefits, to protect those types of things. And they provide certain other exceptions that are not found for the qualified plans. So the qualified plans, again, the only exception is a state or quadro, whereas the non-qualified plans, there are more exceptions about if you can get it within 60 months or less, or you can take it without a penalty. And the way this was argued was that, okay, this guy's over 59 and a half, so there's no IRS penalty, so we should be able to take it. And the Court of Appeals said, that's just not right. And we don't want this to happen to someone else. That's why we're here. And Ms. Tucker can probably speak to that whole 60-month thing with, I think there's something T70, I don't know.
That specific wording, I expect the intention was to make that align with the federal protections that are provided for qualified plans under ERISA. There is a section of the IRS code that allows you to access your qualified funds prior to age 59 and a half without penalty, as long as it's 72T of the IRS code, as long as you take substantially equal payments for a period of at least 60 months. So the fact that on the non-qualified plan, 26-2111, the legislature specifically said for a period of less than 60 months makes it pretty obvious to me that that language was specific in order to make that fall on those qualified plans, clarifying that this is the oranges, the non-qualified plans, and we're not doing anything over here to disrupt the protection for the apples, the qualified plans. So that aligned the protections, the state protections, pretty much in line with what the federal protections are for qualified plans as well. Because when money is rolled from a 401k into an IRA, that money originated in an ERISA plan. It still actually has the protection under federal law of ERISA. However, the Department of Labor, who is tasked with enforcing ERISA, is not going to get involved with those funds once that money leaves that employer plan, because they regulate employer plans. So once that money rolls over to an IRA, it really doesn't lose its ERISA protection, but there's nobody to step in and apply those protections. And so 26-105 is designed to mirror those protections so that when the money leaves the 401k plan or the 457 plan for government employees and educators, that money does not lose that protection at the state level, because obviously state judges can't do anything about enforcing federal law.
And I would say that on one other thing, if I may.
And Ms. Hill, if you just identify yourself when you start talking.
Oh, sorry.
Oh, you're fine.
I'm sorry, Tamara Hill, an attorney in Jackson, Tennessee. The other thing that I was going to say is that if you listen to that legislative history, one of their purposes was to provide the same protection at the state level as these plans enjoy at the federal level.
Thank you. And Representative Bolza.
Thank you, Mr. Chairman. Let me just articulate a concern that I've got and let you react to it. I think it's important that judgment debtors pay their judgments. And it's important that judgment creditors have the ability to execute against a judgment debtor's assets if the judgment debtor fails to pay the judgment voluntarily. Now, obviously, we recognize that there are certain exemptions in the law. I mean, we've got homestead exemptions, personal property exemptions, wage exemptions, and we've got retirement plan exemptions if it's a qualified plan, a IRA, an ERISA plan, all of which have certain limitations in what can be contributed each year. What concerns me about this language is that it purports to exempt not just ERISA qualified plans, but stock bonuses, profit sharing annuity, other types of plans or contracts that could definitely interfere with a judgment creditor's ability to collect the judgment. And so you might have a judgment debtor putting more into these different types of retirement assets than would be fair, because the judgment creditor nevertheless needs some assets against which to execute. So why is it that this bill does not tilt the playing field in favor of judgment debtors, and they're taking assets and putting them beyond the reach of a judgment creditor and against a judgment creditor who has a lawful judgment that should be paid?
Which,
And would that be better to ask the sponsor? Without objection, we'll go back in session and ask the sponsor that. And
Mr. Chairman, could I respond to that briefly?
you can, but identify yourself. And
Darlene Tucker, Certified Financial Planner. Just, and you make a valid point. Judgment creditors should be able to act. This bill does not expand any of the protections for those non-qualified plans. The reason the protections are written differently in 262111 is because that deals with these non-qualified plans where large sums of money can be put in there. Those types of plans in some cases could be used for fraudulent transfer in order to hide assets or protect assets. 262111 has several exemptions that are exceptions to the exemptions that are not applicable to 26105. 262105 protects those qualified plans exactly as you said. This amendment does not expand or contract any of those protections on either side. It specifically clarifies that those qualified plans are not affected by the additional exceptions to the exemption, which is provided in 262111 for the non-qualified plans.
And without objection, let's go back in session, hear from the sponsor about this too. I'd like to hear his response. So without objection, we'll go back in session. And sponsor, would you like to talk about that?
Well, let me tell you, you're not going to get a better answer from me than you're going to get from these experts over here. And as I understood it, it did not, change how it would be applied at all. It didn't expand it. But these two are the professionals with that particular finance. I'm not a financial professional. And but I don't see how it a representative, how it actually expands it to not allow the creditor to have the ability to proceed and secure their debt. I don't see it. But here again, they're better than I am.
Sounds good. And Leader Lambert, you were on the list for a question to the sponsor.
Move previous question.
The question's been called. We're voting to send House Bill 2839 to full civil. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Full civil. Congratulations. And to Ms. Hill and Ms. Tucker, thank you all so much for being here.
Thank Mr. Leader, Mr. Chairman, and members. Thank you.
Thank you. Thank you. That brings us back to item number 1, House Bill 2449 by Representative Miller. Do we have a motion? Do we have a motion going twice? Third and final call for a motion, and bill fails. All right, members, just as a reminder, our next meeting is going to be on April the 2nd, 2024. We're going to skip next week, so anybody want to watch reruns, it's online. So seeing no further business, without objection, we'll stand adjourned.